Hello and welcome to this podcasted lecture on charities. This podcast will be in a number of parts, and in the first part we're going to give a general introduction. Charities are an unusual breed of trust in that they have no clearly ascertainable human beneficiary. Rather, they achieve a purpose which benefits the public. Now, of course, most people are familiar with the concept of charity, but few people realise that many charities exist as trusts. The majority, in fact, exist as trusts. There can also be charitable corporations, but the majority in England and Wales exist as trusts. And charitable trusts are those which are created to carry out a charitable purpose. And in addition, the trust is only charitable if it benefits the public as a whole or a sufficient section of the public. So they're often called public trusts. And charitable status is given to those public purpose trusts which are considered to be of particular value and importance to the community. There are nearly 200,000 registered charities in the UK today. Now, in order to be recognised as a charity, there are four broad requirements which must be fulfilled. Firstly, there must be a charitable purpose, and there are a list of charitable purposes in the Charities Act, and these are expanded upon by case law. The charity has to benefit the public, so there has to be a public benefit. That is, that the trust has to benefit the public either as a whole or a sufficient section of the public. More on that later. Charities cannot be political, so they must be non-political in nature, and finally they must be exclusively charitable. Why do you think somebody would want charitable status though? Well, there are a number of benefits to having charitable status. The first of these benefits is exemption from the beneficiary principle. Now, there are rarely human ascertainable beneficiaries to a charitable trust, for example Oxfam or the RSPCA. So there is no one to enforce them, and we know from our studies of private express trusts and gifts that it's said that no principle has greater sanction in English law than the proposition that a trust, not being a charitable trust, must have ascertained or ascertainable beneficiaries. That is, there must be someone in whose favour the courts can decree performance of the trust. But in the case of charitable trusts, the government has charged the Attorney General with the authority and responsibility to enforce them in the name of the Crown. He does this via the Charities Commission, which is also appointed by government to oversee the proper administration and control of charitable trusts. Secondly, there is exemption from the rules around certainty of objects that we're familiar with from express trusts and gifts. Charitable trusts often have uncertain objects. If we think back to the ascertainability test for certainty of objects in express trusts, a trust for the children would be invalid. However, we do know that there is a registered charity called Save the Children. Provided that the objects are exclusively charitable, such trusts are exempt from the rule regarding certainty of objects. Thirdly, there are also a number of tax benefits, and we'll come on to discuss these a little more in a couple of moments. But as an example, gifts to charity or the creation of trusts for charitable purposes are exempt from inheritance tax, and charities are exempt from many other forms of taxation. Fourthly, there is an exemption from the rule on inalienability, that is, the rule against perpetuities. Now, that rule against perpetuities, i.e. against remoteness of vesting, does apply to charities, but a gift over to one charity following a gift to another is valid even if the gift takes effect outside of the perpetuity period. The rule more generally against perpetual trust, though, does not apply to charities, so there are some charitable trusts in existence today that have been around for several hundred years. Fifthly, the courts will, wherever possible, try and save a charitable intention. If there is a general charitable intention and the particular object fails, the trust fund will be applied si pre, i.e. to objects of a similar nature, rather than allowing the trust to fail with the fund going to next of kin or those entitled on failure. Again, more on this later. And one final point to note on the benefits of charitable status is that trustees can act by majority rather than, in the case of private trust, by unanimous decision. As noted a moment ago on the previous slide, charities are exempt from a number of forms of taxation. And in terms of payments, charities are exempt from liability to pay income tax, provided that the income is applied exclusively to or for the charitable purposes of the trust. Also, no income tax is chargeable on profits from any trade carried on by a charity, as long as the profits are applied solely for the purposes of the charity or the work is carried out by the beneficiaries. Charitable corporations are exempt from liability to pay corporations tax. No capital gains tax is payable where such a gain accrues to a charity and that gain is applied for the purposes of the charity. Transfers from charitable trusts are exempt from the inheritance tax provisions. No stamp duty is due on the transfers of real property from charities, and charities get relief on the payments of local business rates on their properties from 80%. Note, charities do, however, have to pay VAT on their purchases and, of course, may charge it where appropriate. In terms of exemption from taxation for receipts of property to a charity, gifts of any amount in favour of a charity by way of someone's will are exempt from inheritance tax if made by a discretionary trust, and donors can reclaim income tax paid on one-off donations under the gift aid scheme, and charities can reclaim income tax paid by the donor at the basic rate on donations made through covenants of more than 3 years, when people sign up to donate on a regular basis to a charity. The donor can reclaim the higher rate tax paid on the donation made by a covenant. So there are a number of taxation benefits that operate in favour of charities. But why would this be the case? Well, if we think about the sort of work that charities do in helping people in all sorts of different situations, if charities didn't perform the functions that they perform, then where would responsibility for those functions fall to? Well, most logically, that would fall to the state. And the state, in recognition of the fact that charities alleviate the burden upon the state, reward charities with these tax breaks effectively as recognition of the work that they do. So those are the benefits of having charitable status. Next question then is, how do you secure charitable status for your organisation? The answer is quite simple. Your purpose or purposes must satisfy the definition of the word charitable. Put another way, in order to get charitable status, you must be charitable. Question is then, what does that word mean? Well, if you remember earlier, I said purposes of particular value and importance to the community. Well, this is a convenient definition based on the Oxford Dictionary definition of charity in the legal sense, but still doesn't offer much clarity. With so much at stake, one would hope for a precise definition of both charity and of charitable purposes. Instead, though, the courts have sought satisfactory definitions for over 400 years. The scope of charity is based upon a large number of decisions, themselves based on the spirit and intentions of the preamble to the Charitable Uses Act of 1601. These decisions may be either those of the courts or those of the Charities Commission on an application for registration under the Charities Act. The enactment of the newer Charities Act 2006 did, however, provide a statutory definition of both charity and charitable purposes for the first time. The key provisions of that Act came into force in April 2008 and have since been consolidated with other statutory provisions in the Charities Act 2011, which came into force in March 2012. We will come on to the new legislation in a few moments, but first let us look at the history and development, as much of it is still very, very relevant. Charities have a long history in this country. The oldest charity in England is believed to be the King's School, Canterbury, which was established in the year AD 597. And despite some gaps in its history, it still exists today. There are many aspects of the sector which have stood the test of time. For example, the Hospital of St Cross in Winchester was set up in 1136 by William the Conqueror's grandson, and to this day provides accommodation for the elderly and bread and ale to passing travellers who ask for it. So the fundamental principles of charity and philanthropy are deeply ingrained in this country's culture. However, the way those principles establish themselves and how they have been given effect to since is a story of change, reform and growth. The fact that charities are in general administered as trusts is an accident of history more than anything else. The early Lord Chancellors were men of the cloth, clergymen, and so it became administratively neater to organise charities as trusts as part of the exercise of their general equitable jurisdiction. In medieval and early Tudor times, those who wished to give help to those less fortunate could leave their property to monasteries or other religious or public institutions for this purpose. This system was underpinned by the actions of both the aristocracy and the trade guilds to create an informal system for poverty relief, with the all-powerful church at its heart. The first great upheaval in the world of charity came in 1538. Henry VIII's dissolution of the monasteries and the actions of the Reformation ended the power of the Catholic Church and confiscated its property, so putting an end to its charitable work. By the reign of Queen Elizabeth I, the effects of the Reformation, combined with the triple impacts of urbanisation, rapid population growth, and the dispossession of peasant land, had created significant levels of poverty. The Poor Laws of 1597 and 1601 and the Statute of Charitable Uses of 1601 were the major reforms designed to tackle these problems by rationalising and clarifying the relative roles of the state and private charitable donations. The statute on the slide is of particular importance and is sometimes referred to as the Statute of Elizabeth I. Now, the aim of this statute appears to have been to reduce the obligations placed on parishes by the Poor Law to care for paupers. The creation of charities in this way permitted philanthropic assistance to be given to charitable aims in a way that would reduce demand on the coffers of each parish. The statute has long since been repealed, but its spirit has lived on in the common law. Thus, it's been accepted that a purpose is charitable if it can be shown to fall either within the preamble to the 1601 statute, some of which is on the slide, or where it ranks by analogy with one of the purposes set out in the preamble. So you'll note that the preamble to the Act referred to a wide range of purposes, stating that money and lands have been given, some for the relief of aged, impotent and poor people, some for the maintenance of sick and maimed soldiers and mariners, schools of learning, free schools and scholars at universities, some for repair of bridges, ports, some for marriages of poor maids, some for supportation, aid and help of young tradesmen, handicraftsmen and persons decayed, and others for relief or redemption of prisoners or captives. Some points to note: the courts do not and have never given the preamble a literal construction, so that if an object for which charitable status is claimed is not within the preamble, it doesn't mean it would have been refused charitable status. And in the 19th and early 20th centuries, the courts took a much more liberal attitude as to what was within the spirit and intent of the preamble. And so just because an object was upheld as charitable then, doesn't mean that it would necessarily succeed today. The legislation and the framework has, of course, moved on. Now, the preamble contained a general catalogue of the purposes then to be regarded as charitable. Since that time, purposes which are regarded as being within the spirit and intendment of the preamble were regarded as charitable. The law modernised, and the definition of charity cases came from Lord MacNaughton's judgment in Commissioners of ICT and Pemsel, and he categorised them under 4 heads as listed on the slide, putting them into a convenient framework. So he said that purposes would be charitable if they were for the relief of poverty, the advancement of education, the advancement of religion, and other purposes beneficial to the community within the spirit and intendment of the preamble, sometimes referred to as the 4th head, a kind of catch-all head to cover new and developing social purposes. Now, this is obviously not a precise definition, and indeed many purposes could overlap. For example, you could have a gift for the preparation of poor students for the ministry, which would cut across the first 3, and arguably might even go into the 4th as well. But it provided a convenient framework. Now, the language of the preamble was, of course, rather archaic, and the out-of-dateness, for want of a better description, was acknowledged, and the courts have taken a pragmatic and common sense view, recognising purposes which come within the spirit of the preamble to the 1601 statute, as is illustrated by the case on the slide, where the judge said that the purposes must be shown to be for the benefit of the public in a manner within the spirit and intendment of the preamble, not the preamble itself, but the decisions of the court as to its scope, which have attempted to keep the law moving as new social needs arise or old ones become obsolete. So the court's taking a very practical approach, saying what would be for the public benefit in the present day, is how they approach things, particularly through the 19th and 20th centuries. The law began to become codified in the 20th century, though, through a piecemeal introduction of legislation covering a range of issues such as new socially accepted purposes, which would qualify as charitable in the Recreational Charities Act of 1958, and regulatory and procedural changes. After the Second World War, with the introduction and rapid development of the welfare state, it was thought that the role of charities would decline. However, despite the significant changes brought by the welfare state's introduction, fears about the demise of charities proved groundless, and the sector once again reinvented itself, expanding into new areas such as overseas aid and the environment, and setting up new types of service such as the first hospices. With these developments, it became clear that there were some services that charities could simply deliver better, and where they could fill gaps in the services that were provided by the state. The Charities Act of 1960 introduced the first register of charities. It extended the jurisdiction of the Charity Commission over charities that were not trusts, and gave the Commission power to investigate charities. The Charities Act of 1985 gave some greater administrative power and control to smaller charities. Following a further review of charity law in the late 1980s, the Charities Act of 1992 was passed, which modernised the regulation of charities further. A year later, the Charities Act of 1993 consolidated the 1992 Act with what remained of the 1960 Act and some other vestiges of 19th century regulatory rules. Early in the 21st century, and a few years into Tony Blair's government, a far-reaching and comprehensive review and consultation took place, which ultimately led to the passing of the Charities Act 2006, which widened the scope of charity and introduced statutorily recognised charitable purposes. And to qualify as a charity, an organisation has always had to exist for wholly charitable purposes, and those purposes have had to be for the benefit of the public. The Charities Act 2006 did nothing to change this. However, it did aim to clarify what constitutes a charity in the 21st century, with a clearer a more explicit list of charitable purposes, and an emphasis on the public nature of charity. Further to this, it contained a list of 13 descriptions of charitable purposes, including a catch-all other purposes category to allow the law to continue to develop. So this became the most important piece of legislation in the development of charity law, essentially in the history of charities. The 2006 Act also gave the Charity Commission a new statutory objective of promoting awareness and understanding of the public benefit requirement, along with a specific duty to publish guidance on public benefit. The Commission published its guidance in 2008 and followed that with more detailed guidance and specific consultation for groups of charity most likely to be affected. Following on from this, and as part of the Coalition's plans to reduce bureaucracy and red tape, the government decided to consolidate most of the existing legislation into one, producing the Charities Act of 2011. The government also commissioned a review which was reported on in summer 2012. I'll return to this at the end of our podcasted lecture sessions, but in terms of how the statutory provisions now govern charity, the new legislation defines a charity at section 1, subsection 1, as being an institution which is established for charitable purposes only and falls to be subject to the control of the High Court in the exercise of its jurisdiction with respect to charities. Thus, to know whether or not a trust will constitute a charity, we must establish whether or not its purpose can be defined as being a charitable purpose in the following sections of the Act. And a charitable purpose is one which fulfills two requirements. First, it must fall within the list of purposes set out in section 3, subsection 1 of the 2011 Act, as considered on this slide and the next two. And secondly, it must satisfy the public benefit test, which we will come on to discuss a little later in this podcasted lecture. In section 3, subsection 1, there are 13 categories, of which the first 3 and the last 1 refer back to the pre-existing case law on the definition of a charitable purpose. As can be seen from the slide, the first 3 categories are very similar to the initial 3 case law categories from Pendle's case of charitable purpose, whereas the subsequent categories are new. So we have, instead of being for the relief of poverty, we now have the prevention or relief of poverty, the advancement of religion, and the advancement of education in the first 3, very similar to the old case law. But we also have some novel categories. Some of these would have been recognised as charitable using the old catch-all head, but some are entirely new to the Charities Acts of 2006 and 2011. And these include the advancement of health or saving of lives, the advancements of citizenship and community development, the advancement of the arts, culture, heritage or science, the advancement of amateur sport, the advancement of human rights, and that includes conflict resolution, reconciliation and promotion of religious or racial harmony or equality and diversity, the advancement of environmental protection or improvements, the relief of those in need by reason of youth, age, ill health, disability, financial hardship or other disadvantage, the advancement of animal welfare, the promotion of the efficiency of armed forces of the Crown or of the police, fire and rescue services and ambulance services, and finally any other purposes within subsection 4, that is, categories of charitable purpose which are already accepted under the case law of charities. And that final provision is like the equivalent of the old fourth catch-all head and allows the courts to give validity to new and changing social purposes, socially accepted purposes. So the list is not intended to be exhaustive. The importance of the new categories is that they either give validity to some purposes which the case law refused to recognise as being charitable, or that they bring other novel purposes formally under the umbrella of charitable purposes as part of government policy. Now, among the purposes which are now included in the list of charitable activities, which might previously have been excluded by the old case law, are purposes such as campaigning for human rights and environmental protection. Although there are new purposes, an important matter to consider before we move on is the fact that the 2006 and 2011 Acts, which introduced these new heads of charitable purpose, have in fact preserved the validity and the relevance of much of the existing case law. Very little of it, in fact, has been swept away. So it is still relevant, it is still instructive, and it is still useful in defining some of these terms. So in the next part of our podcasted lecture, we're going to take a look at some of the old case law to expand upon what is meant by some of these lists of charitable purposes, some of these heads of charitable purpose, by reference to the pre-existing case law. Hello and welcome to this, the second part of our podcasted lecture on charities. Now, in the first part, we considered a general introduction to the law of charity and how it had developed. We concluded by looking at the list of charitable purposes that is now contained in statute in the Charities Acts of 2006 and more recently consolidated into the Charities Act of 2011. And we said at the end of part one that much of the old case law is still relevant and hasn't been swept away. And so for understanding what is meant by some of those statutory heads of charitable purpose, it is useful to consider some of the old case law to expand upon what is meant. So looking at the first old head of charitable purpose, there is no clear definition of poverty, and its meaning can only be understood by examining the cases on the subject. And in Mary Clark Holmes Trustees and Anderson, Mr. Justice Channell held that poverty was a relative term, which would consider someone to be poor if he or she is in genuinely straitened circumstances and unable to maintain a very modest standard of living for him or herself and the persons, if any, dependent upon him. And in Re Colthurst, a trust for the widows and orphans of deceased bank officers was held charitable under the head of relief of poverty. And Evershed observed that poverty does not necessarily mean destitution, and he paraphrased it as meaning persons who have to go short in the ordinary acceptation of that term, due regard being had to their status in life, and so forth. So what we can say is that poverty is a matter of degree. There are a number of examples of situations in which the courts have held cases of financial hardship rather than grinding poverty to be within the technical definition of poverty. Some interesting examples on the slide. Re Garden allowed a trust for ladies of limited means to be held within that definition. In Thompson & Thompson, a trust for unsuccessful literary men was held to be charitable under the relief of poverty. In Re Young, distressed gentlefolk, and in Spiller and Maud, a trust for the benefit of decayed actors. The fact that we don't know what a decayed actor is, despite its inclusion in the preamble, and presuming it's not to be taken literally, doesn't stop the purpose from being a valid charitable trust. These cases are an illustration of the type of vague trust provision which courts are prepared to admit as valid in the context of charitable trusts for the relief of poverty, whereas these would never satisfy the test for conceptual certainty for private express trusts. So the term poverty itself is interpreted quite liberally. But remember, the head of charitable purpose indicates that the trust must be for the relief of poverty. Or under old case law it said relief of poverty. Under statute it now says for prevention or relief of poverty. But that means we need to define the term relief as well as define the term poverty. And the term relief isn't intended to lead to a complete resolution of the poverty experienced by those who receive the benefits of the trust. As evidenced by Joseph Rowntree and Attorney General, rather, it is sufficient that there be some alleviation of the poverty as a result of the activities of the trust. Therefore, a trust for the relief of poverty of millionaires by means of food parcels would not be a valid charitable trust for the relief of poverty, as there is no poverty that would actually be relieved by such a trust because the recipients are already millionaires. But if there is some alleviation of some poverty, then that would be considered sufficient. It would appear that a genuine charitable intention to relieve poverty by doing something like opening a soup kitchen, however, which also occasionally provided food to people who were not impoverished, would not be invalid, provided that the poverty of others who were impoverished was being relieved. So in Biscoe and Jackson, which concerned the establishment of a soup kitchen for the parish of Shoreditch in London, it was enough that the gift was expressed as being for an institution which had as its purpose the relief of poverty. There are connotations, of course, in opening a soup kitchen of helping the most needy, of helping the poor. And the fact that the occasional person may come along and receive a benefit from that who might not need a benefit did not stop that trust from being charitable, as its principal intention and its principal the principal people who would benefit under it would clearly be impoverished. But if a trust can equally benefit others besides those who are poor, it cannot be charitable. And in the case of Riguion, the trust income was to be applied in providing knickers for boys, unusually, knickers for boys of a certain age in Fareham. And this failed because it could have benefited rich and poor boys equally. There was no connotation of poverty in providing underwear, essentially, whereas providing a soup kitchen does have a connotation of poverty. There have been a number of cases in which the generosity of the courts has been pushed to its limits. And a number of charitable purposes have been expressed to be for the relief of poverty of the working classes. And in Rhys Sanders' Will Trust, there was an attempt to provide dwellings for the working classes in Pembroke Dock. And Mr. Justice Harman held that not to be charitable because, in his view, working classes did not indicate poor persons. However, compare and contrast that with Rena Yaz's Will Trust, where there was an attempt to provide a working men's hostel in Famagusta, Cyprus, and McGarry held that to be charitable, saying that he distinguished that from Rhys Sanders on the basis that hostel indicates something different from dwellings, and when connected with working men has a connotation with poverty. But the courts don't generally consider working classes to be poor people, and it would probably be unwise for a testator to rely on Rena Yaz's, and far better to include an express limitation which refers to the poor rather than simply working classes. We will come on to discuss more about the public benefit later, but an interesting point to note in relation to trusts for the relief of poverty in particular is that it has been held that there does not need to be a general public benefit, and that the settlor has been able to validly define a limited group of people who are entitled. And in Dingle and Turner, the testator directed the trustees of his will to pay the income of his residuary estate to his wife for her life, and then after her death to invest the capital sum on trust to apply the income thereof in paying the poor employees of E. Dingle and Co. Limited who were aged and incapacitated. The ultimate residue of the estate was to be held on similar trusts. At the date of the testator's death in 1950, the company had over 600 employees, and there was a substantial number of ex-employees. The widow died in 1966, and the House of Lords held this to be a valid charitable trust, even though it was expressly limited to poor employees of a particular company, so not for the general public as such. There is also a reference on the slide to poor relations cases, two of which are named, but we'll not discuss these yet, and we will revisit this peculiar area later when we specifically consider the general public benefit test and the impact of the Charities Acts of 2006 and 2011 on the exceptions for poverty cases. So that's the first old head of charitable purpose, that is, the relief of poverty. The second, you may recall, was the advancement of education. Now, the preamble to the 1601 statute referred to the maintenance of schools of learning, free schools and scholars in universities, but the scope of education in the context of charities has been widened considerably by the case law. So we'll have a look at a number of different categories which have been held to fall within education, such as teaching, promotion of culture, research and sport. Note that legislation, and in particular the more recent acts, have now expressly provided separate categories for some of these and others beside, as we discovered earlier. But it's useful to look at the development of the case law, and there is no explanation in the new act formally as to what constitutes education. Naturally, one would expect education to include teaching, but this means in educational institutions all the way from day nurseries through to primary schools, secondary schools, further education and even universities, but doesn't necessarily limit itself to pure teaching and has been interpreted very, very broadly to include things such as the provision of scholarships, physical educational facilities and buildings, payment of teachers and lecturers, and even things like the establishment of museums, libraries and zoos that have an educational teaching purpose. Interestingly, the case of Incorporated Council for Law Reporting and Attorney General shows that the publication of law reports is considered charitable under education, as it teaches us about the law. The promotion of culture has also been held to be educational within the meaning of the advancement of education. For example, the promotion of music, drama and fine art amongst the public. And in Royal Choral Society and Inland Revenue Commissioners, a trust to form and maintain a choir in order to promote the practice and performance of choral works was held to be valid as an educational charity. In Re Dellius, a trust to promote the music of a single composer was similarly held to be educational, promoting culture. And in Re Shakespeare Memorial Trust, a trust to promote the works of William Shakespeare was similarly held to be educational and charitable. Now, of course, it's arguable that the position these days will be slightly different and that these might not be considered purely educational because there is a separate head for the advancement of arts, culture and heritage. But the educational head has historically been quite a broad and useful one. And to include the promotion of culture is obviously demonstrative of that. But there can potentially be some difficulty for the courts in these cases. Now, there is no doubt that trusts to promote Shakespearean works and, say, the art of Turner or Rembrandt would be charitable because the merit of those works is beyond question. But what if an unknown amateur artist leaves money on trust to establish an art gallery to exhibit his portraits? Or who is to say whether they are good or bad? And alternatively, you could say, is the music of modern bands or modern artists educational? Is Lady Gaga educational in terms of the promotion of culture? And the courts do sometimes have to entertain these sorts of questions. In the case of Re Pinion, deceased, there was a gift to the National Trust of a studio and its contents, and it was held not to be charitable because the collection lacked artistic merit. And Mr. Justice Harman, in deciding the case, remarked, "I can conceive of no useful object to be served in foisting upon the public this mass of junk. It has neither utility nor educative value." And in deciding these matters, the courts listened to expert evidence, of course. So, although promotion of culture is accepted as being educational under the old case law, not all cultural matters will be considered to have sufficient merit. The position could now arguably be different because the advancement of culture, arts and heritage have their own head together with science under the recent legislation. But it remains to be seen how the courts will apply and interpret the newer legislation and whether these principles from case law will still ring true, requiring artistic merit. Research will also be a valid educational purpose in many circumstances. The leading case in this context is that of Ree Hopkins. Now, in this case, a bequest had been made to the Francis Bacon Society, whose aim was to prove that Bacon was in fact the author of the works which are generally attributed to Shakespeare. The court held that the fact that the research would be made public would lean towards a finding of charitable status. Now, because the work would be published, it would pass into the store of educative material and could then be used for teaching. So it was held that research can be educational. A case reaching a different conclusion, though, was that of Rhys Shaw. Now, in Rhys Shaw, there was a bequest made by the late, great and famous George Bernard Shaw to be applied towards research to create a new 40-letter alphabet, and it was hoped that the research would lead to a new common language. Now, the trustees were willing to carry out this research. The latter purpose clearly has at its root a commitment to public benefit based on the determination that war and conflict would be reduced if different nations spoke the same language. But it was not accorded charitable status, as Justice Harman held that it involved propaganda, political propaganda. Thus, the decision in the later case of Ree Hopkins on the previous slide, delivered by Mr. Justice Wilberforce, considered Shaw and sought instead to expand the definition of education used by Justice Harman here to extend beyond a necessity that there be teaching. We will see that political purposes, though, would still remain problematic when we come on to consider that requirement later in our podcasted lecture. So it becomes clear that the term education will encompass research, and Mr. Justice Slade, in the case of McGovern and Attorney General, set out the principles on which a court would find that research work would be held charitable. Now, this involves and includes research carried out outside of schools or universities, provided that there is an intention to publish that research or to make its benefits available to the public. And he held that the subject matter of the proposed research should be a useful subject of study, and that it is contemplated that the knowledge acquired should be disseminated to others, and that the trust is for the benefit of the public or a sufficiently important section of the public, so it being made available to either everyone and to pass into the store of educative material or to a large enough group of people. And we'll come on to consider what we mean by a sufficient section of the public when we look at the public benefit test a little later in our podcasted lecture. Sports also historically could be considered as educational in order to get it through. Now, sport has its own head under recent legislation, the advancement of amateur sport. But historically, if it could be tied to education, then that was the only way to get it through. And in the leading case of Inland Revenue Commissioners and Macmullen, it was contended that the playing of sport ought properly to be considered as part of education in the same way that sitting in a classroom is generally supposed to be educational. So the House of Lords in that case considered the charitable status of a trust created to promote the playing of association football and the playing and coaching of other sports. And they said that provided it is within schools or other educational establishments, then this would be acceptable. Lord Hailsham saying that this purpose was educational because sport was essential to the development of young persons as much as sitting in a classroom and learning. However, sporting purposes would not in themselves be charitable under the head of education. In Re Nottage, a cup for a yachting competition was held not to be charitable, and in Re Patten, similar, but for cricket. And the reason being was that there was no link to education. See also the case of Re Mariette to support the idea that the link to formal education had to be present to gain charitable status. But note again that the position would now in all likelihood be different under the advancement of amateur sports head in the more recent legislation. But it's not just sports, as in the traditional view of sport. that was or could be considered to be educational. The courts have held that sometimes pastimes are educational in themselves. So the case on the slide concerned a trust to provide a prize for a yearly chess tournament for boys and young men in Portsmouth. Where to draw the line is a difficult issue, and Mr. Justice Vasey was uneasy about the limits on this charitable educational purpose when he validated this trust to provide funds for an annual chess tournament for young men under the age of 21. He said, "One is on a rather slippery slope. If chess, why not drafts? If drafts, why not bezique, and so on through to bridge and whist, and by another route to stamp collecting and the acquisition of birds' eggs. Those pursuits will have to be dealt with even when they come up for consideration." So you can see he had a problem with opening it up generally to pastimes, but felt chess was acceptable as an educational pastime, as it involved thinking about things like strategy and tactics, things that could be considered transferable skills. So you can see that the scope of the education head was very wide indeed, and this historically at least has made the head a very useful one in practice. The impact of the 2006 and 2011 Acts, though, in providing additional categories will arguably diminish its use going forward reasonably significantly, and you will probably find that teaching and research will broadly be covered, but things like sports and pastimes will move into other areas, as well as promotion of culture. So that's the second of our old heads of charitable purpose. The third head, as you might recall, was the advancement of religion. Well, what is religion now? Well, let's have a look at the old case law. In Bowman and Secular Society, Lord Parker suggested that any form of monotheistic belief, that is, belief in one God, will be recognised as a religion. Now, the law tends to adopt a tolerant stance towards religion and seems to be reluctant to enter into value judgments in this area. So the head has embraced quite a wide field. All Christian denominations are included, that is, the established church, Roman Catholic, Baptists, and also including things like the Salvation Army. But the case law definition wasn't confined to Christianity, though. Neville Estates and Madden, the Jewish faith was accepted, and in Barrett and Attorney General, there's a suggestion that Islam would also be acceptable as the law developed and as England and Wales began to become a more cosmopolitan, multicultural jurisdiction. The general view, though, was that there had to be a God, and only one God at that. So monotheism was the order of the day. More on that in a moment, though. One thing to note before we move on is that gifts made virtute officii may also qualify, and also other things that could be considered to be satellite purposes to religion. So in Rees Simpson, a gift to the vicar for his work in the parish was considered to be charitable for the advancement of religion, and in Re Bain, a gift for such objects as the vicar shall think fit was held to be charitable for the advancement of religion by virtue of their office. Additionally, as indicated, satellite purposes have been accepted as being indirectly connected with the advancement of religion. In Re Royce, the benefit of a church choir was recognised to be the advancing religion within the meaning of this head of charitable purpose, and in Re Moons, a bequest for mission work was similarly held to be for the advancement of religion. Also note that the physical accoutrements of religion, such as the erection or maintenance of the fabric of a church or place of worship, or part of the building, such as a window or the roof, would qualify as being for the advancement of religion, or the maintenance of a graveyard as a whole. Note, though, maintenance of a specific tomb will be considered a private purpose and therefore would not be charitable, and would have to stand or fall as to whether it fit with one of the exceptions to the general principle that private trusts must have an ascertainable beneficiary or beneficiaries. But the law, as it developed under case law, broadly took a tolerant stance to any monotheistic belief, that is, any belief in a single God. As indicated a moment ago, I said there would be more on the old case law requirement for there to be a God. And in Re South Place Ethical Society, Mr. Justice Dillon said, "Religion, as I see it, is concerned with man's relations with God. Ethics are concerned with man's relations with man. It seems to me that two of the essential attributes of religion are faith and worship. Faith in God and worship of that God." So a very specific requirement that there must be a God and only one, and that God must be worshipped. Now, the Church of Scientology is not charitable in the UK. In the case of Hubbard and Vosper, Lord Denning described Scientology as dangerous material, and Justice Goff described it as pernicious nonsense in Church of Scientology and Kaufman. Now, for those unfamiliar, Scientology is the relatively recently formed religion which is adhered to often by very high-profile celebrities such as Tom Cruise and John Travolta, and includes the belief that we are all aliens awaiting to be rescued by the mothership, and that this was dismissed by both Denning and Goff as indicated, as it didn't involve belief in a God in part. There are other forms of religion which have been accepted. The Unification Church has been accepted as a valid charitable religion. The distinction being there that there is an element of worship in a God, whereas there wasn't in either the case illustrated on the slide or the Scientology cases. But Freemasonry is not a religion for the same sorts of purposes as Church Scientology not being a religion. So we can see that the case law definitions generally supported belief in one God, a solitary God, monotheism, only as religion. But what of Hinduism, which has many gods, or Buddhism, which technically arguably has none? And there are other forms of godless religions. How would they be dealt with? Well, under the old case law, clearly they wouldn't have been accepted. However, the law has moved on. And under the 2006 and the 2011 Acts, Section 321A explicitly provides now that religion includes a religion which involves belief in more than one God, and a religion which does not involve belief in a God. So these two would expressly cover Hinduism and Buddhism, which may not previously have been included under case law. Hudson has commented about the potential danger of including religion which does not involve belief in a God, observing that this arguably opens up the claim to belief systems more generally, and it begs the question how one draws the distinction between a religious belief or a belief, for example, in the existence of hobbits, or Spider-Man, or the Tooth Fairy. Hudson also observes that the new Act has the potential, therefore, to validate Scientology, previously described, as noted a moment ago, as pernicious nonsense and dangerous material. Although, note the last general observation on the slide from case law and from the general public benefit requirements. A religious body will not be registered as a charity if its tenets are morally subversive or its purposes are not directed to the benefit of the public. So there is still a safety net, as it were, if a court feels that a particular form of worship would be harmful to the morality of the public. So that's advancement of religion. Now, of course, different people hold different views in the area of religion. Some hold the view that the advancement of religion might not benefit society at all. Others, of course, question how, when there are competing religions, how advancing many of them at the same time actually advances anything. It arguably puts things into greater to conflict. This, of course, is also the subject of extensive writing and research, but it is a discussion which is beyond the scope of this particular session. It may well be picked up in further discussions in our workshops in due course. So that's the three principal heads which had a specific purpose ascribed to them. That is the relief of poverty, the advancement of education, and the advancement of religion. Finally, in looking at the old case law that still has some relevance, we come to the old fourth head, which arguably has not only been preserved by the 2006 Act and the 2011 Act, but has also been expanded on hugely with the additional heads. Now this head provided, and arguably the 13th head now, provides a residual group of charitable purposes which it's almost impossible to define precisely. Not every purpose which might, by common consensus, be considered to be beneficial to the community could come within this head, but it has been interpreted quite broadly and does allow the law to recognise new and developing purposes. And historically it's done this by reference to the preamble, which arguably is still what the catch-all head will do by looking at the spirit and intendant of the preamble. So in Reed Dunlop, a case for the aged, in Reed Rash's a case for the sick, and in Reed Lewis a case for the disabled, all of which were held to be valid charitable trusts, even though none of them fits the other three clear heads of poverty, education or religion. They were other purposes beneficial to the community. Note this heading also includes trusts for social, recreational or sporting purposes. The Recreational Charities Act of 1958, which has largely been preserved by the later legislation and has now been consolidated into the 2011 Act, declared charitable the provision of facilities for recreation or other leisure time occupation in the interests of social welfare, provided it's for the public benefit. Now the requirements in the legislation is that the facilities are provided in the interests of social welfare, and that condition is not satisfied unless the facilities are provided with the object of improving the conditions of life for the persons for whom the facilities are primarily intended. But in Guild and Inland Revenue Commissioners, the House of Lords considered that the meaning of that should be a very broad meaning, and it suffices that objectively facilities are capable of improving conditions of life for such purposes, rather than necessarily that they have to actually improve the conditions of life under such purposes. Animals generally used to also fall under this fourth head. These are actually amongst the most popular charities in the minds of the public. People would generally rather give to fluffy kittens and puppies than to other human beings, it seems. And their inclusion in the other purposes beneficial to the community rested upon a process of reasoning by analogy, rather than because of the words of the preamble. Essentially, the reasoning in including the welfare of animals before it was specifically recognised under the more recent legislation was that encouraging kindness to animals promotes feelings of humanity and morality generally. It represses brutality and thus elevates the human race. And that's the arguments that were put forward by the court. So trusts for the welfare of animals generally have been charitable under this head, though gifts for specific animals are not, as they would be private purpose trusts potentially. They could be valid as private trusts, as one of the notable exceptions. But examples of the sort of things that would be charitable trusts for the welfare of animals would include a home for lost dogs in Reed Douglas, and trusts for the benefit and protection of animals more generally in Reed Wedgwood. So it's generally accepted that the prevention of cruelty could be charitable, and always was under this old catch-all head, saying that it elevated the human condition to think about the welfare of our fellow occupants of the planet. But what if the prevention of cruelty conflicts with some human interest? This happened in National Anti-Vivisection Society and Inland Revenue Commissioners, where the object, given the name of the proposed society, was obviously the abolition of vivisection, i.e. experimentation on animals. Here the court had to balance the benefit to society by prevention of cruelty to animals with the benefit to society of vivisection as a part of medical research, and when you put that animal interest versus the human interest, medical research won. Under the 2006 Act, and that's been consolidated into the 2011 Act, there are now two distinct heads for animal welfare and then separately for the advancement of health and saving of lives. So whilst they don't require such creative thinking as they once did in order to be valid, the two interests may on occasion still compete, and I would suggest that it's likely that human interest will be considered to outweigh animal interest where the two did come into conflict in the minds of the court. That concludes the second part of our podcasted lecture. In the next part, we're going to come on to consider the public benefit requirements. Hello and welcome to this, the third part of our podcasted lecture on charitable trusts. In the first two, we've considered generally an introduction to what charity is and how charity law developed, and we've considered the list of charitable purposes and how the old case law helps to explain what's meant by those charitable purposes. Now, in addition to meeting the different requirements for each head of charitable purpose, there are three further requirements that also need to be considered in deciding whether or not a gift could be considered to be charitable. The first of these is the public benefit. And the public benefit requirement involves two elements. Firstly, there has to be a tangible benefit, and secondly, the class of persons to benefit must consist of the public as a whole or a sufficient section of the public, and not a private group of individuals. And there are different tests for what constitutes a section of the public or a section of the community depending on the head of charitable purpose. If either of these requirements is not met, then the trust is not charitable. Now, in terms of why the law insists that a trust or a body must involve public benefit in order to gain charitable status, it has to be remembered that charitable trusts enjoy significant tax exemptions, and trusts and organisations that confer no ascertainable benefit on the community, and those that only further the interests of a very small number of people, should not enjoy the fiscal benefits of charitable status. So the public benefit requirement really justifies the tax exemptions that charities enjoy. In terms of breaking down the two elements of public benefit, firstly, a tangible benefit. Establishing a tangible benefit doesn't pose a problem for most trusts and for most organisations seeking charitable status, but it does depend often on the head of charitable purpose that you're talking about. The old fourth catch-all head has been the most difficult and burdensome to establish, and trusts covered by the other heads have, at least historically, been assumed to have a tangible benefit to the community, but there have been some notable exceptions to that. We noted in the previous part of our podcasted lecture that the advancement of religion generally is considered to be charitable, and that the courts have been happy to support any form of monotheistic belief before the introduction of the more recent Charities Acts of 2006 and 2011, which broadened the definition of religion to include polytheistic beliefs and beliefs such as those contained in Buddhism. But Gilmore and Coates concerned a trust for a contemplative order of nuns, Catholic nuns, who didn't leave their cloisters. They argued that the trust should have been charitable because their prayers brought a benefit to everyone, and that their self-denial and their pious lives were beneficial in that they provided an example to us all. The House of Lords, however, held that this was not charitable. The arguments were rejected, and the court felt that the benefits of their edifying example and their prayers were too vague and incapable of being proved to be of tangible benefit to the public. So the public benefit test requires the trust to confer some tangible benefit directly or indirectly upon the public, but does not require a benefit to be available to all of the public. It's enough that there is a possibility of benefit being conferred upon a section of the public, but as indicated earlier, this requirement varies from head to head of charitable purpose. What do we mean by saying that the public benefit test depends on the head of charitable purpose? Well, the public benefit requirement covering a section of the public varies from being almost non-existent at all in poverty cases to being a very heavy requirement under the old fourth head of other purposes beneficial to the community. Let's look at what we mean in a moment, but first let's consider the impact of the Charities Acts of 2006 and 2011. Now, the public benefit under the Charities Act 2011 is outlined in Section 4, and it says that a purpose falling within Section 3.1, i.e. the 13 heads, must be for the public benefit if it's to be a charitable purpose, and in determining whether that requirement is satisfied in relation to any such purpose, it is not to be presumed that a purpose of a particular description is for the public benefit. On the face of it then, subsections 1 and 2 taken together would almost go against what was said on the previous slide about it depending on the head of charitable purpose. But note subsection 3, where it states that any reference to the public benefit is to as that term is understood for the purposes of the law relating to charities. In other words, it's possible to argue that the old case law remains relevant in determining what the public benefit might be for this type of charitable object. Note further though, there is a provision in subsection 4 which states that subsection 3 is subject to subsection 2. So there's somewhat circular reasoning being given here by the government, to say that no particular purpose should be presumed to be charitable, but that the old case law is still relevant, but then you need to be aware that no purpose should be presumed to be for the public benefit. So it goes round. Why are we so concerned about the potential change though? Well, this is particularly important when we look at poverty cases. In the previous part of our podcasted lecture, you might recall that I mentioned poor relations cases and said that we'd come back to them. Well, now is that time. Last time I said it's a peculiarity with reference to the rules for charitable trusts for the relief of poverty that the settlor can validly define a limited group of people who are entitled to benefit from the trust, and can even show a nexus, a connection with the intended beneficiaries. What you cannot do is give a charitable gift to specific named individuals, but in Re Scarisbrick, a trust for such relations of my said son and daughters as in the opinion of the survivor of my said son and daughters shall be in needy circumstances, was held to be charitable, as it was a trust to relieve poverty among a class of people and not a trust for specific individuals. Re Cohen also backed up that point. So prior to the Charities Act of 2006, which consolidated in 2011, the courts were very lax in the public benefit requirement, allowing a settler to validly define a very narrow group of people to benefit. And we see that principle expanded further in the case of Dingle and Turner, which we also discussed in the previous parts of the podcasted lecture. Now, as indicated, we mentioned Dingle and Turner last time, but in essence, it was an approval by the House of Lords of the extension of the poor relations cases to cover poor employees. Basically, this was approving the idea that in poverty cases, the section of the public to benefit didn't need to be large, or even particularly public. Hence why I observed earlier that the test has been virtually non-existent in poverty cases. And it was held in that case that whether or not the potential beneficiaries of a trust could fairly be said to constitute a section of the public was a question of degree, and that much must depend upon the purpose of the trust. But what of the more recent legislation and the changes that has brought? Well, I said before that it was arguable that the old case law was still relevant, but there was that proviso that subsection 3 was subject to subsection 2. So is that in fact the case, that they are still relevant, these old decisions around poor relations and poor employees? Well, in essence, yes. The Charity Commission has, so far, upheld the view in its guidance and drafts that poverty cases may be treated as under the old case law. These cases are anomalous in the field of charity. A personal nexus, i.e. a link of blood or common employment, would normally be fatal to charitable status, and a class so defined would be construed as private. But under poverty, that rule seems to be very, very relaxed. Under the head of advancement of education, the public benefit requirement, however, is much less relaxed, and the starting point of the modern law there can be found in the case of Re Compton. In this case, a trust for the education of the descendants of 3 named individuals was not charitable, as the beneficiaries did not amount to a section of the public. And the test referred to in Compton, it refers to a personal nexus. Now, personal nexus is some kind of personal quality, such as a relationship to an individual or as between individuals. In Re Compton, the children didn't form a section of the community, a section of the public, as they were linked by a personal nexus of common blood. Note that the nexus does not have to be with a settlor. It's some characteristic as between the beneficiaries which separates them out from being part of the public and makes them a private group of individuals. Now, this obviously can be immediately contrasted with the poor relations case, where for poverty, as long as the beneficiaries are defined as a class, then common blood is not the problem. But for education, it's much more stringent. Now, almost as a natural progression, we arrive at the case of Oppenheim and Tobacco Securities Trust. In this case, there was a trust for the education of the children of employees or ex-employees of British American Tobacco Company Limited. And Lord Simmons here applied the Compton test, saying that also that the class must not be numerically negligible. Lord McDermott dissented in the case, saying that whether a trust was public or private should be a question of degree and can only be decided on the facts of the particular case. And as the potential number of beneficiaries is so large in this case, he would have considered it to be charitable. But the majority of the court held that it was not charitable, saying that it failed on the personal nexus of common employment, even though at the time there were more than 110,000 employees, not to mention the number of ex-employees, and then when you start to factor in the number of children they may have all had, the potential pool of beneficiaries could be 500,000 people, yet that wasn't considered to be a section of the public. Unsatisfactory though this test is, and it was criticised by Lord Cross in Dingle and Turner, the personal nexus test does apply to educational trusts. Ever since taxation was invented, people have sought to find ways to minimise their tax bill. The same is true with educational trusts, in that people have sought to find ways around the personal nexus rule. One way that has been successful is to set up a trust for the primary benefit of what is clearly a public trust, and then expressing a preference for a private class. This is what happened in the next case, Recottigan's Will Trusts. Now here there was a trust to promote commercial education amongst members of the public, stating, "It is my wish that the trustees should give preference to the employees of a particular company and their families. That preference was limited to no more than 75% of the trust income per annum, and it was held to be a valid charitable trust." And although this case has since been described as edging very near to being inconsistent with Oppenheim, it was held valid. The important point to note here, though, that is that if it is to work, it must clearly be a preference to the private group and not an absolute right in favour of the private group. Also have a look at the case of Inland Revenue Commissioners and Educational Grants Association, 1967, in your textbooks, for where a similar scheme failed. Continuing on the public benefit test in general under case law, we come to the case of Inland Revenue Commissioners and Oldham Training and Enterprise Council, where here there was a trust whose objects included promotion of vocational education and training and retraining of the public, and to promote industry, commerce and enterprise for the benefit of the public in and around Oldham, Greater Manchester. This included advice to new businesses. Mr. Justice Lightman held that the object of promoting trade, commerce and enterprise, and the ancillary object of providing support services and advice to new businesses on any fair reading must extend to enabling them to promote the interest of individuals to engage in trade, and therefore felt that companies' objects promote primarily the interests of individuals, private interests, and other entities, as opposed to the interests of the public, and so held that this would have to fail. Further on the issue of the public benefit, we come to the case of Baddeley, where here there was a trust for the promotion of religious, social and physical well-being of the residents of West Ham and Leighton, who were or were likely to become Methodists. The House of Lords decided that the trust wasn't charitable in part because of the inclusion of social purposes, but for other reasons as well, more specific, that the class was defined in one way and then more narrowly restricted beyond that. And the view was that there is a requirement for a general public utility, and therefore, in order to be charitable, it must benefit the public as a whole or a sufficiently wide group, like the inhabitants of a particular area. If the group to benefit is resituated any further than that, there is a danger that it's not a trust of general public utility. And Viscount Simmons, in the case, held that the charitable purpose would have to fail on that basis because the class of those who could benefit was too narrowly drawn, referring to the concept of a class within a class. This was supported by Lord Somerville in the case. And Viscount Simmons explained what he meant. He said, one must observe the distinction between a form of relief accorded to the whole community, yet by its very nature advantageous to a few, and a form of relief accorded to a selected few out of a larger number equally willing and able to take advantage of it. And an illustration was given by Lord Simmons in the case. He said, a bridge which is available to all of the public may undoubtedly be a charity, and it is indifferent how many persons actually use it. But confine its use to a selected number of persons, however numerous and important, it is then clearly not a charity. It is not of general public utility, for it does not serve the public purpose which its nature qualifies it to serve. So the fact that it was for residents of West Ham and Leighton would have been fine, but the fact that it was then resituated further to require them to also be Methodists or be likely to become Methodists made that group a class within a class. And if you have a situation of a class within a class, then that makes the group a private group and not a public group, and therefore it does not pass the public benefit test. So that's public benefit. The third requirement that charities have to satisfy in order to achieve charitable status is that they must be non-political. But what do we mean by non-political? Well, even if, at first sight, a purpose appears charitable because it is, for example, for education, it will not be charitable if one of its main activities is political. Of course, many well-known charities seek to influence decisions of Parliament on subjects relevant to them, and therefore it would appear that some political activity is acceptable. But in McGovern and Attorney General, Mr. Justice Slade described 5 examples of political purposes. And these included furthering the interests of a particular political party, trying to change the laws of this country, trying to change the laws of a foreign country, trying to procure a reversal of government policy or particular decisions of government authorities in this country or abroad, or trying to, that refers to UK government policy and possibly foreign policy and how it influences abroad, and then trying to reverse government policy or particular decisions of foreign governments effectively. Now, McGovern itself concerned a trust to procure the abolition of torture or inhuman or degrading treatment or punishment in all parts of the world, and therefore that would have required changes in the law and failed on the basis that it was political. But why do political objects fail? Well, there are broadly 3 reasons that are advanced. The 2 principal ones are given on the slide and are policy reasons. Firstly, the courts say that they cannot judge whether a proposed change in the law, either here or abroad, will or will not be for the public benefit. And secondly, that as far as changes in the law in the UK are concerned, the courts must decide cases on the principles that the law is right as it stands, since to do otherwise would usurp the functions of the legislature. Now, this seems to relegate the position of a judge to one of an automaton. We know full well that we live in a common law jurisdiction, that judges do actively make law. Particularly in our studies of equity and trust, we find that judges are quite keen almost to make law and to bend the law to individual situations. So many argue that these policy reasons that are advanced are something of a cop-out, a judicial cop-out, allowing judges not to enter into politically sensitive areas where it suits them. A third reason that is advanced for not allowing political charities is that as the Attorney General is an officer of government, it would potentially put him in a conflict of interest if a particular charity were to go against the wishes of his employer, effectively trying to procure a change in the law or policy of his particular government. So there are arguments around a conflict of interest and arguments that judges should not be making these decisions on such politically sensitive issues. But as noted earlier, political activity in some respects is clearly permissible, as charities often try to influence the development of law and policy in a way that helps them to further their objects. And political activity is acceptable if it's considered to be ancillary or incidental to the achievement of the main charitable object. For example, animal charities such as the RSPCA, whose main objects are to prevent cruelty to animals, may have incidental powers to try to promote changes in the law to further their main charitable object. And incidental political activity of that nature doesn't jeopardise charitable status. Further example would be organisations such as Stonewall, who campaign for lesbian, gay and bisexual rights. They were particularly keen on the debates around same-sex marriage in summer of 2013 and encouraged people to write to their MPs in support of changing the legislation. So that sort of activity, if it's ancillary to the main object, is acceptable. The main object of the RSPCA is prevention of cruelty to animals. The main object of Stonewall is around LGBT respect and equality. So that's not necessarily that their principal purpose is political, but they do have some influence on the political process, potentially, in order to achieve their main object. In terms of how this non-political requirement applies, there are some examples which are taken or adapted from real-life cases given on the slide. So given the first one, for the advancement of adult education on the lines of Labour Party principles, those facts are taken from Re Hopkinson, 1949, where the trust was held to be non-charitable because it was, and I now quote from the judgment, nothing more than political propaganda masquerading as education. I think you might be able to tell the political leanings of the judge in that particular case, not being pro-Labour. But in any event, that's clearly in the first category outlined by Justice Slade in McGovern, promoting the interests of a particular political party. Compare and contrast that with the second example, to educate the public in forms of government and in political matters generally. That was held to be charitable in the case of Retrust of Arthur McDougall Fund in 1956. The reason being was that it was not espousing the views of a particular political party, nor promoting a change in the law. It was general political education and awareness of political systems, and so on and so forth. That clearly doesn't fall foul of any of the 5 categories listed by Mr. Justice Slade. And finally, an object to procure the total abolition of vivisection and, for that purpose, the repeal of the Animal Scientific Procedures Act 1986 and the substitution of a new act prohibiting vivisection altogether. These objects in that example are similar to those contained in National Anti-Vivisection Society and Inland Revenue Commissioners in 1948. And the House of Lords decided that the only way to secure the abolition of vivisection was by Act of Parliament, and therefore the main object was wholly political. And if the main object is entirely political, trying to change the law or policy, then that will fall foul of this requirement. So that's 3 out of our 4 requirements considered. We now come on to consider exclusivity of charitable purpose, the 4th and final formal requirement. And to be charitable, the funds of the trust must, under the terms of the trust instrument, be allocable for charitable purposes only. Now, generally speaking, if any part of the funds can be used legitimately for non-charitable purposes, then the whole trust is not charitable. We saw the case of McGovern a few moments ago when looking at political objects. This case is actually also relevant on this point because it combined charitable purposes, including research into human rights, with non-charitable political purposes such as trying to change the law by procuring the abolition of torture or inhuman or degrading treatment. Now, this case actually concerns Amnesty International. And the way Amnesty International have sought to get around this latterly is to hive off activities, their campaigning work on one hand and their research work on another hand, allowing them to gain some charitable status for some of their activities. But in this particular case, it was struck down as not being exclusively charitable. And to judge whether or not the trust is exclusively charitable, you need to study the trust instrument or the will which sets out the purposes. And if the trust document provides that the trusts are to be used for benevolent or public or philanthropic purposes, then those purposes aren't considered to be charitable. You need to fit with one of the heads of charitable purpose very, very clearly and can't be described in such vague or loose terms. But what of the position when the trust document uses both charitable and non-charitable words to describe the permitted purposes, such as charitable and benevolent objects? We said a moment describing benevolent is too vague, or charitable or benevolent purposes. Well, the approach that's adopted by the court depends on whether the purposes are linked by the word and or the word or. And it's important that the settlor's purpose be exclusively charitable. That means that the settlor won't be able to confuse a charitable with a non-charitable purpose and hope to have that trust recognised as being charitable, gaining all of the tax benefits that flow therefrom. The case law has taken a very strict approach to this question in many cases, and if the settlor were to declare that the property be held on trust on trust for charitable or other purposes, then the trust would not be a valid charitable trust, because that could potentially mean that the funds of the trust could be applied for the charitable trust or for the other things. So the word or is disjunctive, making the charitable and non-charitable purposes alternatives. The whole fund could be applied either way, and therefore it's not charitable. As authority for that, see the case of Blair and Duncan, where the language was charitable or public purposes. The court felt that public being listed as an alternative to charitable must have meant that public did not mean charitable. On the other hand, the courts have interpreted the word and to have the connotation of an intention either that the trustees administer the trust in a charitable manner, even if it is some other incidental purpose that's to be achieved, or that the purpose must also be charitable, or at least not detract from the underlying charitable purpose. So the word and is generally construed as being conjunctive, meaning that the charitable and other purposes are to be read together, authority being Re Sutton, where charitable and deserving objects was understood as meaning that deserving must mean charitable. However, it's not always the case that and is conclusive, and that's particularly notable when you have a list of charitable purposes. And in the case of Williams and Kershaw, there was an attempt to set up a trust for benevolent, charitable and religious purposes, which was held not to be charitable, despite the fact that charitable generally clearly is intended to be charitable. Religious, as we know, would qualify under the advancement of religion. But they held that charity was found to be only one of three purposes in which benevolent generally does not mean charitable. So when you have a list of charitable purposes, then they aren't read conjunctively. But in summary, usually the word and means it will be exclusively charitable, as the word would be read conjunctively. And the word or would mean that the two purposes are alternatives, and therefore it means that the whole fund could be applied either way, and it's not exclusively charitable. There are some minor exceptions, however, to exclusivity. First of these is where the non-charitable object is incidental to the main charitable object. Under this first exception, a trust will be charitable even though it includes non-charitable objects, provided that they are incidental to the main objects. An incidental purpose is one that's ancillary and conducive to the attainment of the main charitable purpose. In the Royal College of Surgeons case on the slide, as well as its main purpose of promoting the art and science of surgery, the college also gave assistance and protection to its members in the form of sort of union protection. And that latter purpose, though not charitable, was seen as merely ancillary and was accepted. The second exception is where the non-charitable purpose is severable. And severance is possible if the court can quantify the amount intended for the non-charitable purpose as against the amount intended for the charitable objects. In the case of Salisbury and Denton, the courts applied the maxim equity is equality, but it may not always be appropriate to do this. So that broadly concludes the main requirements for charitable status and concludes the third part of our podcasted lecture. In the fourth and final part of our podcasted lecture, we'll pick up on looking at some ancillary matters around what happens in the context of failure of gifts on charitable trust. Hello and welcome to this, the fourth and final part of the podcasted lecture on charities. In the first three parts we've had a general introduction and we've considered the requirements of charitable purpose, public benefit, the non-political requirement and exclusivity of charitable purpose. Here now we pick up from where we left off in part 3 by considering some miscellaneous issues such as what happens on the failure of charitable gifts. And before we actually move on to consider that, some scenarios are listed on the slide. So imagine that a testator's will contained a legacy to Honiton Primary School, but that the school closed down before the testator's death. What would happen to that legacy? Now, if we're thinking about private trusts where a beneficiary predeceases the testator, then the doctrine of lapse would apply. And so you would expect that might be the same thing here. Or what about where a will creates a trust of £50,000 to build a new 4-bed ward at Manchester Hospital, but either the money is insufficient or planning permission is denied? What would happen there to the funds? You might think if the object isn't capable of being carried out, then there would be a resulting trust for the settler's estate. But is that the case? Also, think about the situation where there's a public appeal which has raised £60,000 to provide a recreation ground at a site for preschool children in Harwich, but that there's a surplus of £5,000 left over at the end. What would happen to that fund? You might again assume that there will be a resulting trust. But there are special rules which exist to save charitable gifts or to sometimes reconstrue them when they seem to be impossible to carry out. And these rules are part of the special treatment that's afforded to charities. The law strives, in general, to preserve money for charity through the application of certain rules. In general terms, for failure of gifts, if the gift is to a charitable institution which has ceased to exist, it can be saved if the institution is in fact continuing in another form on the authority of Re Faraker. If the gift was a purpose trust, and the purposes are being continued by a different trustee, then the money can be paid to the new trustees unless the identity of the original trustees was a vital part of the settler's intention. On the authority of Re Vernon's, if the charity amalgamates with another charity so that some of its original funds are still applied for the same or wider purpose, then the gift can be paid to the amalgamated charity. But where the institution is not continuing or the charitable gift or trust is otherwise impossible, it may still be possible to apply the subject matter for purposes that are similar through what's known as the C. Pray scheme. If none of the above save the gift, you should consider C. Pray. In such a case, the trustees of the charitable trust are under a duty to apply to the court, or more usually the charity commissioners, for approval of a C. Pray scheme directing how the money is to be used. C. Pray is a rough translation from the Norman French to mean as near as can be. And the doctrine has been used to save gifts to charity so that funds are applied for purposes as near as possible to those selected by the donor. But before considering whether or not it can be applied, it's necessary to distinguish between what's known as initial and subsequent failure, because these are governed by different rules. If the failure is initial, CPRE only applies if the settlor or testator had a general charitable intent, whereas CPRE automatically applies in cases of subsequent failure without the need to show such general charitable intent. In terms of making the distinction between the two types of failure clear, initial failure refers to the situation where failure occurs where the gift or trust is impossible from the outset, and the outset refers to when the disposition takes effect. Obviously, for lifetime dispositions, this is the date of the execution of the trust instrument, but for gifts by will, it's the date of the testator's death, because that's the point at which the will becomes effective. Subsequent failure occurs where, at the date of the lifetime gift to the testator's death, the gift or trust would be possible, but later becomes impossible. It becomes frustrated by some later event. So, in cases of initial failure, the courts have to look for this general charitable intent, where at the outset it was never possible to achieve. The courts look for this general charitable intent. And essentially what the courts try to do is to deal with the property as the settlor or testator would have wished. Now, where the wording of the gift or the trust suggests that the testator would have been content for the property to go to a similar charity if the suggested project or gift were to fail, the court will give effect to this general charitable intention by means of a CPRE scheme. You'll recall that cases of subsequent failure are automatically eligible for CPRE. There is no need to show a general charitable intent on the part of the settlor or testator. The property at that stage has already been dedicated to charity, and therefore it could never return to the settlor or testator's estate through a resulting trust, but would be applied as near as can be CPRE to a similar charitable purpose. But in cases of initial failure, CPRE is only available if the court or charity commissioners are satisfied that there was this general charitable intent. Unfortunately, the concept is rather elusive. As examples of general charitable intent, if the gift is to a body that has in fact never existed, but the name that's used suggests a general charitable object, then on the authority of Re Harwood, the court will find something as near as can be as to the suggested name. And if the failed gift appears in a will that contains a large number of other charitable gifts for kindred similar objects, then on authority of Re Satterthwaite's will trusts, then that will similarly be an example of a general charitable intent, and the court will find a similar scheme to those that are kindred. There are special rules for public appeals for charitable purposes that fail in Section 63 of the Charities Act 2011, and this permits funds raised by public appeal to be applied to CPRE without the need to provide a general charitable intent on the part of each donor. So suppose that £12,000 is raised to build a new wing at a local hospital, but the hospital in question then closes down. What can be done with the unwanted funds? It's hardly practical to return them to the donors, as most will have remained anonymous, especially if done by public collection boxes and such the like. So in such circumstances, it would be convenient to apply the money CPRE for a similar charitable purposes, even though the donors gave their money for a specific project and they therefore didn't possess a general charitable intent. Section 63 says it's convenient to apply them to a similar charitable purpose where the donors can't be traced. Note it only applies where the property belongs to people who can't be identified or have executed written disclaimers, so it has no application to trusts other than those concerned with public collections. That now covers what happens when gifts fail, so we move on to consider just some concluding comments in relation to charities. So let's have a quick recap of charities in general. Now, charitable trusts attract a number of benefits. Those benefits include taxation, exemption from certain rules which govern private trusts such as perpetuities, certainty of objects, and the human beneficiary principle. But in order to qualify, they must have a charitable purpose. That is, they must satisfy one of the 13 heads of charitable purpose as outlined in Section 3, subsection 1 of the Charities Act 2011. Now, although this statute gives a clear list of charitable purposes, not all of them are necessarily adequately explained. And so much of the old case law is still relevant in terms of the explanation of what's meant by things like poverty, education, and so on and so forth. In addition to having a charitable purpose, a trust must also satisfy the relevant tests for public benefit. And remember that this breaks down into two elements, that there has to be a tangible benefit and also that the benefit be available to either the public as a whole or a sufficient section of the public. That latter requirement around a section of the public is interpreted very liberally in the case of poverty charities, but is much more stringent in relation to the other heads. Charities, of course, cannot be political. Political purposes include things such as advancing the views of a particular political party or changing law or policy in this country or abroad. And the reasons that are advanced for that are that judges have to decide cases on the basis that the law is right as it stands, and also that judges aren't qualified, according to the policy reasons that they advance, to decide whether or not a change in the law would be for the public benefit. But some political activity, as long as it is ancillary or incidental to the main object, is permissible. Finally, charities have to be exclusively charitable. That is, all of the funds have to be allocable for charitable purposes only. There are again some very minor exceptions to exclusivity. If a gift fails, you should consider whether or not it could be saved through the doctrine of si pre, but note, si pre only applies in a situation where the first four requirements have been met. So there has to be a charitable purpose, there has to be a public benefit, it must not be political, and it must be exclusively charitable. Si pre only applies where those four things have been met, but then something else frustrates the carrying out of the charitable purpose, such as the refusal of planning permission after the funds have already been vested in the trustees, if the funds were to build something. That's an example of subsequent failure, where it was possible at the time the gift was made, but became impossible at a later stage, in which case the trustees of the charity would have to apply to the court, or more likely, the Charity Commission, in order to seek direction on a similar scheme through si pre. Charities is obviously quite a large area, and there's a lot written in any of the most recent textbooks. It is important that you refer to up-to-date textbooks, as obviously the implementation of the Charities Act 2011 in March of 2012 has changed the landscape to some degree. There are also useful updates provided on the Charity Commission website. The link is provided on the slide, but www.charity-commission.gov.uk is the address. And on there you will find guidance notes, you will find latest news and information, and this is particularly useful if you're considering any of the new statutory purposes, things that aren't covered by the old case law, or weren't covered explicitly necessarily by the old case law. Also, I mentioned earlier that there was a widespread review of charity law more generally, which was reported on in summer 2012. That was Lord Hodgson's review of charity law, and there is further reading available if you find the link just using the internet, searching for Trusted and Independent Giving Charity Back to Charities. There is likely to be further statutory developments in the coming years, so it would be worth keeping up to date by looking at those documents there. That concludes our podcasted lecture on charities, and in the next podcasted lecture we'll be considering implied trusts.